heard that.
All righty, I'm going to ask everybody to stand for the Pledge of Allegiance. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All righty, so it's somewhat of a special meeting this morning. We have one agenda item, and that's a public hearing and first reading to consider ordinance MC 2102, a temporary ordinance regarding the issuance of local medical cannabis establishment permits and/or licenses. Eric Bogue. Eric, good morning, sir. Thank you for being here and for taking care of us.
Absolutely, Mr. Eric Bogue, Deputy State's Attorney. The ordinance in question, I believe all of you have a copy or was put into the Dropbox system. If not, I can certainly run quickly, make copies. You all have copies? Okay. This is essentially my attempt to meet what I understood the general conversation that we had at our last meeting on this topic to be, in that a recognition that IM 26 requires that the state adopt certain rules to promulgate those rules no later than October 29th, and that with those rules give us guidance on what will be or not be permitted under the state law, and thus what would be permissible for us at a local level to regulate and adopt as well. Until such time as the state rules are in place, that leaves a substantial amount of gray question mark or whatever other language you prefer to use. And so with that, this draft ordinance just recognizes the adoption of IM 26, certain parts of IM 26 that give the local government some flexibility, and of course the requirement that the state adopt those rules. And in the end of the day, the meat and potatoes of the actual ordinance itself on page 2, sections 1 and 2, simply say that we're going to wait. They will be required to get a local license and or permit. Those permits will not be, licenses or permits will not be issued until such time as the state adopts their rules. I did add additional period of time, 60 days, so it's not later than. We can certainly act faster than that following the adoption of the state rules. But understanding that while we will see those rules coming, it's still possible that something will need to be tweaked on whatever we and or the task force that you're also participating in will come up with as a working draft prior to the final adoption of those rules. And we will need a first, second reading and publication before those ordinances at a local level will take effect. With that, that's the 60 days that will give us a little bit of wiggle room to make sure that we're kosher on our level before those things take effect and we start issuing permits and licenses at our level. I know I've covered that fairly quickly, so if there are any questions, again, this is just my attempt at a draft. If you have any parts of the whereases that you prefer to have changed or altered, certainly please let me know that. We can make those adjustments before the second reading. I wouldn't think any of that would be considered a substantial alteration to the first reading, but I would leave that final determination open depending on what your determination is today. Again, the final action that you will be taking is just those two sections at the bottom. The second section, I'm sorry, I didn't cover that, is immediate effect because it is an emergency to take effect promptly upon passage at the second reading and publication, not waiting the additional normal 20 days after that.
All righty, so this is a first reading. We will take public input, and then I'll go to questions from the commission. So, is anybody here for public comment? Good morning and welcome.
Good morning, guys. It's always nice to see your smiling faces. My name is Sarah. I live at 4509 South Tennis Lane here in Sioux Falls.
What's your last name, Sarah?
Coob.
Coop?
Yep,
Okay,
Coob.
thank you.
And no disrespect, but this sounds like a moratorium to me, okay? I'd rather you guys do nothing. I'd rather you vote it down than to do this. And the reason why is because it gives them permission to drag their feet longer. And we don't know what the Supreme Court's going to do. And I can almost bet it's going to be, okay, rec, June 29th, June 30th. And then it'll change everything, and October 29th won't matter anymore. We'll be looking at February or March of 2022. This way, they have to kind of work around us a little bit because we've invested our time and money already. And this gives me the opportunity, July 1st, to do what I need to do for my business, okay? And if you guys put this ordinance into place, it's gonna make it so that people can't organize their business. And I'm sitting here going, I just don't think that's fair. We've spent a lot of time. There's been 3 elections that went by. We voted this in, and then we have reps kick it out. And now we finally think we have a bulletproof thing, and they're still dragging their feet on it. The medical marijuana administrator for the Department of Health, I applied for that position, and I was told that everyone would get an email on when the position had been filled or if they were going to get a call back. I haven't received an email. This is 2 weeks before July 1st. And I'm sitting here going, they're dragging their heels. And it could be very strategic to make sure that we don't get cannabis until Kristi Noem wanted us to. Okay? And I'm asking you guys not to give that power. Vote this down if this is the idea. Because I really think that it's meant to be obstructionary. I think that it's meant to cause strife. And I think that South Dakotans are pretty good about managing their lives. And that they can make their decisions on this. They voted it in. July 1st, it becomes legal. Why should we stand in the way of anything they want to do with it? So, thank you very much for your time, guys.
Thank you, Sarah. We also take comments from Zoom. I'm going to ask that people do limit their comments to 3 minutes. Kevin, is there anybody on Zoom that has requested to comment? Okay. All righty. So, anybody else in the hallway? All righty. I'm going to close our public comment then, and I'm going to go to the commissioners for questions, comments. Commissioner Barth.
Well, I guess the first thing I'd like to point out is, in talking to our council, apparently the ordinance proposed by the city of Sioux Falls and being voted on this morning down in Lincoln County, all 3 of them are different. And I don't know if that's a wise thing. I mean, we appointed people to the committee. Gerald, have you had a meeting?
Not yet.
And so we'll have conflicting, you know, they may not substantially be different, but lawyers have a way of finding a difference and exploiting it. And I guess that's my first comment. And I have more later.
Well, if you want to hold them, and we can go to other commissioners for other comments. Commissioner Bender?
I'm in favor of this ordinance. I think it's the only wise option available to us. I think we have to have rules from the state before we can, so we know what the rules are before we can pass an ordinance related to the sale of medical marijuana. And so I'm in favor of the ordinance.
I totally agree. I think there's too many unknowns, and frankly, we could be starting over October 1st. And I really think that we all need to be close to having the same page of restrictions.
Commissioner Heiberger, do you have comments?
Yes, sir. I am also in favor of this. We don't want to have, our dealers go out there and start putting their businesses together to later find out that the county and the state have put other rules in effect and cost them money. Medical marijuana is legal July 1st. Nobody's going to get arrested for it. It's just we need to make sure we have our ordinances in line, and so I will be supporting this. The task force will be meeting and making recommendations.
Thank you, Commissioner. A couple questions for Eric, if you don't mind. Explain the impact if we did nothing. I mean, if we didn't pass this, what would happen? Does it change anything? I mean, we still have to wait for the state.
Well, yes, in some respects, the sale may become convoluted in the county because the state has not taken action yet. But the convolution and uncertainty is, in my opinion, problematic. There will be folks that will make substantial financial investments into locations and business structures. This helps avoid those problems before they get too far down the road. There certainly could be legal arguments that arise because of that investment. The public will be uncertain as to where legally they can purchase those things. There are issues about homegrown as well. As has been commented already, the consumption is not the issue here. That's the sale of the medical cannabis establishments, and the licensing or permitting of those establishments is the only part that this ordinance addresses.
Okay, so the likelihood of being prosecuted for a very small amount of marijuana and having a medical use of it is probably unlikely. I'm not the state's attorney, and I'm not going to speak for Daniel, but I mean, we're not doing anything about the consumption. This is about the sale and cultivation.
That's correct.
Okay, so not to put words in our state's attorney's mouths. Sorry, Daniel. My other question is the 60 days, and I'm trying to figure out, is it better to be no later than, or should it be no sooner than? Because if it's no later than, we're saying if you don't apply after 60 days or before the 60 days, you can't apply?
Well, my thinking, again, with the understandings that I gleaned from our last meeting, is that you wanted to be ready to go as soon as you were able to, ready to act, you meaning the Minnehaha County, as soon as the state had adopted their final rules. As we don't know when that date will be, and we don't know what those rules will entail or cover, there may be things that our task force or our own individual planning in our office may not be able to predict and be ready to react to until we actually see that final set of rules. With that in place, there was the thought being that we wanted some additional time after the adoption of the state rules to be able to respond or react to those things if we needed to. But yet we didn't necessarily want to say it would be an automatic 60 days after that. If I've misunderstood or put some drafting in that you folks aren't comfortable with, it's a fairly easy and non-substantive change to make it no sooner than rather than no later than.
Commissioner Bender.
Well, and I would just add that, I mean, the point here is that we aren't trying to be obstructionary. I mean, we are trying to give business owners an idea of a time frame where we will act. And so saying that we will act within 60 days after the rules are issued, I think shows that we have full intent to adopt rules once we know what the rules are that we have to work under. And so I think it makes sense personally to leave it no later than 60 days. It puts, gives us a deadline. Deadlines are always good things, keeps us all moving in the same direction.
Okay.
I think there's also a possibility, although maybe remote, that the state may act before their October deadline too.
I wish I had a crystal ball to be able to tell you that.
I
but
said remote.
I have hopes as well,
Yep.
Commissioner, that they will actually have something going and/or that we'll know with some certainty even before final promulgation of those rules, what the rules will in all likelihood look like. And with that, we'll be able to respond and be able to hit the ground running at the same point that they make those rules final at the state level.
And we have not heard anything on the Supreme Court's ruling on recreational marijuana.
Amendment A, no, I have not seen
And-
any final ruling from them.
If they should come out and rule that the constitutional amendment is valid, how would that impact this?
Well, they are certainly cannabis-related, both topics, but this is the ordinance in front of you, proposed ordinance in front of you today, is only about medical marijuana and refers only to IM 26 and the statutory provisions and guidelines that we, at least at this point, know exist within that structure. So it on that level, doesn't impact Amendment A at all. That would need to be a separate type of ordinance structure. To the extent that we would have any ordinance structure, that's a much different kind of conversation.
Okay. I can see problems. Okay.
Mr. Chairman, if I might continue.
Please.
You know, I guess I worry that our state has no intention of passing these rules. I worry that, in fact, the nefarious folks that live out in Pierre and operate out there are trying to torpedo this. And it's interesting that in a pro-business state, we're trying to protect people by not letting them go into business. You can't go into business because we are here to protect you. That concerns me. Another thing is that with the delay, what are the people that are suffering from cancer, glaucoma, seizure disorders, can we delay their treatment? That's what we're doing when we don't allow this to go forward. MS, et cetera. And I don't see this as being a friendly suggestion by the state that trust us. How can we trust them? That's why they passed a constitutional amendment for recreational, because the state over and over takes these IM things and dismantles them and puts it back in the name of lobbying reform or something, when in fact it isn't lobbying reform. Now that said, I think I'm probably neutral on this. So aren't you glad I'm not against it? But I don't see this as being a step in the right direction. I only saw this at 2:30 yesterday afternoon. I am not a lawyer. The other communities are passing different ordinances. What is McCook County doing? What is Pennington County doing? Mr. Bogue, do you have any idea what they're doing?
Mr. Chair, no, Commissioner Barth, I really do not know with any certainty, even with our relatively joint jurisdictional cousins of the city of Sioux Falls, city of Del Rapids, and Lincoln County are doing, let alone McCook, Moody, or Turner County, or Pennington County in that matter. I would, if I could, Mr. Chair, address your earlier comment and just totally sympathize with your concerns what Pier may or may not be doing, but I would remind you that the delay on the administrative rules deadline was actually part of the initiated measure. So that the folks advocating for medical marijuana have in fact themselves put that delay in for the state rulemaking process. So that's part of the original initiated measure. That's nothing that was adopted by the legislature or pushed by the governor.
Good point. Thank you. Okay. And to your point also, there's people that are investing millions and millions of dollars into property and equipment and locations, and I know of at least two on 41st Street that are looking to open up. So without having the groundwork and common rules for everybody to follow, it just makes sense for us to be able to, just like alcohol, just like tobacco, to at least have some regulatory authority over all of these things. So, all righty.
Will there be a second reading on this, or is this it?
Sure. There needs under state law to be a second reading. The only difference on the emergency effective date is whether it takes effect immediately upon publication or whether it's publication and then an additional 20-day waiting period.
Thank you.
So what we're going to look for is a motion to set the second reading, okay? And we can do that next week?
You can do that as, needs to be 5 days between the two readings is all.
So we can have the second reading next week.
Okay. Commissioner Heiberger, any additional comments? Commissioner Heiberger, did you have any comments?
No, I do not. I'm ready for a motion. I'd make a motion to approve the ordinance with setting second reading on June 15th.
Okay, motion for second reading, or second hearing date of June 15th with the emergency adoption clause to be effective immediately.
Second that.
We have a motion and a second. I'm going to have a roll call vote.
Barth,
Aye.
Benninger,
Aye.
Bender,
Aye.
Heiberger,
Aye.
Karski.
Aye, motion carries unanimously. All righty. So we have a second reading date of next week, and we are at the opportunity for public comment. Anybody here for public comment?
Sarah Koob, 4509 South Tennis Lane, Sioux Falls. The city council also has some things scheduled for the 15th as well during this time frame. So how is that going to work out for me to be at both meetings at once?
The city council meetings are at 6 in the evening, and ours are at 9 in the morning.
Okay, so it will be at 6 for them then. Okay, because I thought that they had it arranged to where it was going to be earlier, and I was like, oh, so.
If they do, I'm not aware of it, and we don't try
Okay.
to sync our schedules up with them, so.
Okay. Thank you,
Okay,
sir.
Thank you, Sarah. I'll look for a motion to adjourn.
So moved.
Second?
All those in favor say aye.
Aye.
Opposed, same sign. We are adjourned until, yeah, we got a meeting tomorrow morning. Actually, budget hearings begin at 9 a.m. tomorrow morning, so see you all.